So I think we're going to get started.
All right. Great. Welcome, everyone. We are so excited to welcome you today to today's final session for 2019 in the Teaching Justice webinar series. Today, the topic, as you all know, is teaching environmental justice through transactional law. And we're so excited to have our presenter with us, Camille Penu from the Community and Economic Development Clinic at UC Irvine School of Law.
So I'm Layla Halas, the Director of Experiential Learning at Tulane Law School, and I'm the co-chair of the Best Practices in Pedagogy Committee of CLIA. And this webinar is part of a larger series that's a project of the Best Practices Committee. We plan, just like last year, to feature a number of innovative faculty who are thinking about how to teach justice in the classroom and drawing from current wisdom in resistance movement, examining the intersections with criminal justice, immigration policy, environmental justice, racial justice, among other issues. Our next session is going to be in January 23rd, where we are going to hear about teaching justice by keeping families together. That the information about that webinar and all of our future webinars is on the Teaching Justice website, and that's where you also can find recordings of this video starting next week.
And I failed to mention earlier, I'm Allison Korn. I'm the Assistant Dean for Experiential Education at UCLA Law. And just a couple of logistical notes before we begin. This session is being recorded, and like all of our sessions, we're going to post it on CLIA's Teaching Justice website after its conclusion. That's also where we have information, as Layla mentioned, for our upcoming lineup of webinars for the spring and into the summer. We have muted, I think, most all of your videos and audios. If we haven't, please do mute both of those on your own to ensure less distraction from our presenter. We encourage questions throughout the session. You can simply use the chat box, which is on the bottom of your screen on the toolbar, to send a chat message to Camille, who will try and respond wherever possible. We hope that these sessions will all be interactive and incite a lot of discussion even beyond today's session. So without any further comments, we will begin, and thanks again to Camille and to all of you for participating.
I started talking with mute on. Thank you so much to everyone for participating. I'm very grateful to CLIA for putting this together. I am super excited to speak with all of you about this topic, and let's dive in. I think it'll be super fun. So one moment, I'm going to try to do a screen share because I was told that folks were not excited about using participatory andragogical methods in these sessions. So I'm going to try to do something a little more traditional. If you disagree with the method, just let me know. I'm happy to alter it. Okay. I apologize. This is going to take just a second. Okay. Can everyone see my screen? No, they cannot, it looks like. Hi, okay, sorry. So can everyone see what I'm seeing? Oh, can only see clouds. Okay, that's unfortunate. Layla, I apologize. Do you mind taking over the PowerPoint for me? Since my screen is acting up, and then thank you so much. I really appreciate it. And then I'll just say slide when I want to move, but I apologize to everyone for the snafu. This is 100% my technological ignorance. Perfect, awesome. Okay, so let's go to the first slide if that's all right. Excellent, thank you so much. So for today's session, my hope was to go through a couple of framing remarks first to help set the parameters for kind of what I would like to talk about. So I'll talk a little bit about what environmental justice is, how it's understood by community members in the movement for environmental justice, and then I'm going to focus on the core principles of environmental justice and how those apply to law practice. Once we go through how they apply to law practice, then I'll be able to kind of give you the framework for how we've been, or how I've been working on this, both through the Community Economic Development Clinic and also through the Water Justice Clinic, which was my first experience in clinical education over at UC Davis. So that's our roadmap. So let's go to the second slide. So environmental justice is principally a racial justice issue, and it certainly has intersectionality with class, immigration status, gender identity and expression, and a number of other orientations and identities. However, it's important to not lose focus that environmental justice problems are fundamentally created through systemic racism in how we have designed our cities, our land use processes, and our economy. And the reason I want to start with that framework is because I think, or at least in my limited experience, environmental justice as an area of practice is often marginalized both within civil rights practice and within environmental law practice. And so, environmental law often looks at environmental justice as kind of a fringe issue historically. And civil rights, I think, civil rights practitioners often see the racial dynamics, but frame a lot of what happens around environmental justice, not as an environmental justice issue, and instead see environmental justice as kind of, unless it's grassroots, environmental justice law practice is often assumed to be focused entirely on environmental law. And that's not entirely true. And so I'm hoping to kind of add a couple of layers of depth to how we understand what environmental justice practice looks like. I think we've seen a bit of a shift in that already, particularly with the rise of discussions of climate justice, a Green New Deal, just transition. So there's kind of greater nuance in those frameworks. And it's important, I just want to make it very clear that this movement is very old. It was kind of articulated more precisely in the late 80s and early 90s, but it's existed since prior to the 1800s. There have always been issues, even prior to industrialization, around the racial effects and the racial inequality in access to environmental benefits and exposure to environmental harms. So with that, I wanted to start with the preamble of the environmental justice principles. So in 1991, there was a gathering of, it was called the People of Color Conference on Environment. And it included advocates from throughout the nation, some international representatives, and additionally, folks representing tribal communities who were trying to articulate common fights that they were experiencing in an individual capacity throughout the country. When they came together, they were trying to articulate a different vision of what environmental access and justice looks like. Historically, environmental law is really focused on pollution control, and particularly in the United States, more so than any other nation. We theoretically protect public health, but when push comes to shove, if it is not economically expedient, there are a lot of ways to get out of having to protect environmental health, and instead to essentially ask polluters to just kind of limit a little bit of their pollution without actually attempting to pursue a pollution-free or pollution reduction or harm reduction model for environmental management. The one exception to that would be in vehicles and cars. There's a little bit more technological innovation and forcing that happens in the regulatory model. So with that in the background, folks didn't want to talk about environmental harm as a disproportionate and solely a disproportionate impact or a intentionally discriminatory racial process, although it was often the problems we see now are the product of intentional racial discrimination. They wanted to articulate an alternative vision for what an environmentally just society would look like. And so when they did that, they came up with, I believe it's 21 principles. I've excerpted only a few of those, and so this is not the original text, but I'm happy to make that available. And so I highlighted the parts of the preamble that I think are most important. So it begins with a long statement of values. So this is all bullet points from the preamble. And I think the key things I would like to call out in this is that it talks very specifically about building a movement, a social movement, and acknowledging that that's the framework of change. It talks about the destruction and harmful effects of economic processes and land use planning on specific communities. I think a lot of this was drafted with communities like tribal nations and international development, where you see multinational corporations run amok. However, it was also talking very concretely about places like Houston, where you have a significant number of petrochemical plants right next to low-income communities of color, particularly Black communities. So it was acknowledging the kind of violence of traditional community development narrative and the ongoing violence of kind of how we structure our economy. And because of that, one of the things that it calls out very specifically is to promote economic alternatives. So one of the critiques that I often hear about environmental justice is that it's a form of NIMBYism, so not in my backyard, for poor people or people of color, which is, you know, aside from being a deeply offensive critique, is also just not accurate. Environmental justice as a movement is fundamentally interested in social transformation, and it's interested in a structural analysis of the things that create this environmental justice inequality or environmental inequality. And it's also specifically interested in imagining a new world. And so in some ways, this coincides pretty closely with the World Social Forum slogan, which is another world is possible. That's kind of the animating principle of environmental justice. It's a combination of an acknowledgement for the values of environment that go beyond just an economic process. So the spiritual value of the environment, the health benefit of the environment, just, you know, caretaking function of the environment, but it also acknowledges that our current system of economic organization doesn't work. And it particularly calls out the need for a liberation theory, essentially, or a liberation-oriented model of change, both on the political, economic, environmental, and social frames or planes. And so all of that is really useful as framing, because it's going to jump into kind of what I talk about in terms of transactional law. So let's go to the next slide, please. So here are another set of excerpts. Like I said, there's 21 principles, so this is not all of them. If we can go to the next slide, Layla, I have called out the ideas that I think are the most, oh, sorry, go back one. Thank you. I've called out the ideas that are, I think, the most interesting within the principles that they've articulated after the preamble. So there's an explicit acknowledgement of the idea of reparations, and that environmental harm has been done to people. I didn't include this principle, but there's a principle that says that essentially the United States or any government that facilitates environmental justice is committing a crime against humanity, essentially, or a hate crime or a crime of terror on communities. And I think that international rights norming is important to acknowledge, because, as I mentioned before, the United States has not historically talked about environmental benefits in the context of human dignity. And I think a lot of what's important about the environmental justice framework is that we are talking about human dignity, community power, and the rights of communities to be free. And so, so it talks about self-determination as well. It talks about the right to participate as equal partners at every level of decision-making, which is significant because it's acknowledging that oftentimes policy is very hierarchical and top-heavy, or sometimes grass tops E, and that this is essentially a statement that no social change is legitimate unless it comes from a grassroots and democratic process. And then it also includes a note about the need to clean up and rebuild cities and rural areas in order to come into balance with nature, and then to affirmatively expand access to environmental goods to everyone, or to ensure that they have that access to the full range of resources. And when they say full range of resources, they don't mean just like parks and clean air. They're talking about, or the principles are talking about, social equity as well. Next slide, please. So from that, I pulled out kind of the themes that I think are most relevant to transactional law practice. So if we think about the principles as a statement of objectives or a statement of goals, it's articulating that there's a right to reparations, a right to self-determination and liberation, a right to participation in decision-making, and a right to an environmentally just economic system. Next slide, please. So one of the things I'd like to highlight is that what this means in terms of law practice is that environmental justice is not just a topic or a substantive area, it's also a methodology. So you could be bringing a lawsuit that has benefits for an environmental justice community, so a community affected by racial inequality and environmental harm. That is not really EJ lawyering. And it doesn't mean it's illegitimate. I'm glad there are people working on those cases. But generally speaking, when we think about environmental justice, it's important to remember that portion about liberation, self-determination, and the right to participate in decision-making. And some of that is kind of counter to the traditional narrative of lawyering, which ends up being often very client-oriented, sometimes overly focuses on the court as an area of reprieve, and sometimes also over focuses on the state to the exclusion of private actors and private conduct. And so I just wanted to put together a little flowchart to show how the principles kind of actualize and how we measure the metrics, or how we kind of come to how we determine whether something is working or not. So if the principle is the right to decision making, then the method is community and movement lawyering. So it's the idea that the lawyer is not calling the shots. The lawyer is a facilitator and a arbiter of access for low-income communities. So when I talk about this with my students, I use the analogy of a lock and a key, and I tell them, you could either be the lock that prevents communities from accessing resources, power, and forums that they are usually excluded from, or you could be the key that they wield as a tool to access power. And so the objective throughout all of this, when we're thinking about environmental justice, is advancing and building community power. So if it's not building power, I would argue that it's not actually, representation is not actually achieving environmental justice as the end goal. It may have benefits, but without the method and the substance, you can't really get to a just conclusion. Next slide, please. Sorry, next slide. Oh, here we go. Sorry, you got it, Layla. Sorry. The one that I want to focus on is a little bit on transactional law. So if the objective is an economy that is not based on things like the GDP, which measures how much we use every year and how much we spend, it doesn't measure other metrics of economic well-being. And if we believe in economic self-determination, we're talking about independence to a certain degree, right? We're talking about freedom. We're talking about the opportunity for people to access economic opportunity without having to compromise their physical health or their well-being or the well-being of their community. So in the context of environmental justice practice for transactional law, what that often means is we're talking about community and worker ownership of economic processes. And we're talking about things like the Green New Deal, just transitions towards better outcomes. So for example, one of the communities I represented when I was a baby lawyer had it's one of the only hazardous waste plants in the nation that accepts benzene, which is incredibly toxic, among other toxins, and it's located adjacent to a very low-income farm worker community, and that was my client. My client wouldn't say, like, it's not accurate to characterize my client's position as they don't want a toxic waste dump in their backyard. They don't want a toxic waste dump in anyone's backyard. Their concern is, why do we have a system of economic process that allows us to create and use toxins such that we then have to throw them away in places? And so it's really important when we're teaching transactional law to kind of go back and think about the structural context of what's happening and whether or not we think that economic system is achieving environmental justice goals in terms of acknowledging the spiritual dignity of people, the inherent value of the environment and the relationship of people to their environment, equal opportunity in public health and in resources and in access to fair and just opportunity and economic and political power, and whether it's building power. Next slide, please. Okay, so now I'm going to just talk at you all for a little bit so we can undo the slide share and go back to my just my video screen, I guess, if that's okay. I'll just talk until we get there. So one of the things that I think is super helpful about transactional law is, or maybe let me go a step back. I think one of the downsides of transactional law is that there's often a push in public interest and social justice lawyering, and I'm not saying this is true of clinicians, but there's often a desire to dismantle or critique the current economic system without offering an alternative. And I don't think that the critique is invalid. I think it's super valid, and it's important for it to be there because it creates pressure. But one of the things that I find students end up being ill-equipped to do is to figure out, okay, if I think our economic system is racist and it's unjust and it enriches the most wealthy at the expense of the labor and health of the most vulnerable, then it's important for them to also be able to articulate or to understand how the system is set up so that they can dismantle it. And Alina Ball talks about this a little bit. She has an article coming out soon, hopefully, on structural competency. And I think that's really the value of transactional law. We do an excellent job of talking and teaching systemic and structural racism and inequality in the context of direct client services and even litigation and policy advocacy. There's less work that's been done, although there's a rising number of scholars in this space, including folks like Renee Hatcher and Lenise Panton and Priya Bhaskaran, among others, who have been talking about the role that transactional law plays in understanding structural inequality and then reframing it for the concept of a solidarity economy. And so transactional law becomes a really powerful tool for the implementation of ideas. When I was in the field, or when I started as an attorney, my clients had said, I worked for an organization that had historically only litigated. And I had spent all my summers in litigation. And my clients said, you know, everyone keeps litigating. However, we're really tired of suing to keep bad things from happening. We would rather affirmatively claim space. And that notion of affirmatively claiming space has really taken off. We see significant activity around this in Detroit with Black radical economic thought. We see some of it in Philadelphia with community land trusts. So these movements have pre-existed lawyers' involvement, but lawyers have a really important role to play in helping communities facilitate the process of getting access to those resources or affirmatively claiming space. And so in teaching transactional law, it's important to match the skills with the political outcome. And so in the context of how I used to teach my class, a lot of the work I did focused on helping them understand the ways in which really crazy things could appear in very boring places. So I can't remember who said this, but I had a colleague who quoted it yesterday, and I just thought it was so smart. And it was, if you want to do something really evil, hide it in something really boring. And so I feel like that's kind of how people think of transactional law, right? If you want to do something really evil, hide it in a contract, bury it in a clause in small print, you know, do it through a process that's private where there's no public kind of participation or oversight. And I think one of the best things, or one of the most helpful things about teaching environmental justice through transactional law, is that we're helping students close the gap. So they understand the structure in the context of the state and the legal system. They don't always understand the structure and context of how law applies to private actors and the ways that private actors also structure that inequality. So one of the activities we do, one of the first activities we do actually, is we have them go through a simulation based on real clients, and then they work on cases that are the same. But one of their assignments is to do a contract review. Sounds super boring, but the contract review is entirely involved around a very low-income community that doesn't have access to water justice. They have no safe or clean water. It has disappeared. I put the setting in Oz because it was the least problematic imaginary context I could come up with, but I'm sure it's problematic as well. So, you know, the Emerald City has built a new processing facility. It is poisoning the river that runs by Munchkin land, and our clients are the Munchkins, and they no longer have access to safe water. And so they are trying to determine whether they should enter into an agreement with the Emerald City to consolidate their water system. Sounds kind of, you know, possibly out there, but it's a good example of the kind of work we're doing with our clients. And so our clients are often being asked to consolidate with a larger city system. They are worried that their votes will be diluted, that they will lose control and power over their utility rates, that they won't be able to have access to oversight because they can merge their system without necessarily annexing in a new area. So they might not have any voting power over the folks who make decisions on their behalf. And so we go through all of this like draft contract, and we call out whether or not we think there's adequate community consultation, whether there is an adequate acknowledgement of the harm that's been done to the Munchkins. Should the Munchkins have to pay for the consolidation, or should the Emerald City have to pay since it ruined their water source? So I try to thread in those concepts of reparations and the concepts of inherent inequality, and that when you're drafting or reviewing a contract, you're not starting from zero. You have to understand the history of how the client got there. The other thing it encourages is that there's a period of time, students get 2 weeks to do this, and there's a period of time in which they can interview the client. And so we have them interview folks who get a script from me or who get some like guidance, and they have to navigate what the client is afraid of. And having to go through all these contract terms with the client is also difficult. So they have to think about, how do I translate these ideas into language that is legally sound, but still accessible to my clients. We talk a little bit about language access in the contract also, and obligations to provide things in multiple languages to ensure adequate oversight. And so that's an example of one project or one assignment. The other area where a significant amount of kind of thinking about transactional law and EJ comes up in when I teach clinic. So when I had an advanced clinic for the Water Justice Clinic, all students were required to do a movement building project. And it could be one of many things, like the deliverable could be very variable, but they had to work directly with an environmental justice community or a community organization that served environmental justice communities in a grassroots-based building way. And they had to come up with a policy. So for one student, they were asked to do strategic research to help the community group come up with a legislative policy on a bill. For another group, it was to consult on the implementation of California's greenhouse gas emissions. So we made California as a cap and trade system. People are paying for credits. Some of that money has been set aside for low-income communities of color who have environmental justice problems. So it was consulting on how to ensure there was adequate public representation and control and oversight of that fund, for example. And for some folks, it was doing community presentation. So it was very traditional kind of know your rights work, but it was aimed towards strengthening the capacity of community members to claim ownership over their resources and decision making, particularly with respect to environmental benefits. So we were a water justice clinic, that was our focus, but our students did also work on climate change issues and energy production and other things that often make people go cross-eyed with how technical and detailed they can be, but that require someone who's not an engineer to think about the social context and say, like, wait a minute, is this really serving the goals of our community? Is it really building their power, or is it taking it away? And then we ultimately ended up changing our evaluation criteria for how we accepted clients. So originally we accepted any client who was an environmental justice community and was and met certain low-income standards. Over time, we realized that that was not adequate, in part because our clinic represented the entire state of California, so we couldn't do community lawyering in, I think, the most meaningful way that it happens. We could do movement lawyering, but we didn't have the benefit of being on the ground. And so our evaluation criteria for clients changed to ensure that they received support and funding from a trusted community-based organization that could help them with the community organizing aspect of what they were doing. And so all of those elements became really important to us because we felt like if we couldn't build their power through transactional law, there needed to be some kind of benefit or bolster. So my other plug for transactional law is that even if you do litigate, after you litigate, there's always the issue of was the judgment fairly carried out? So kind of the infamous case in the regions where I work is Hinckley, California, which was the community in Erin Brockovich that had its water contaminated by illegal dumping from PG&E, which was the major utility in California for electric production. And so the community won. It was a mass torts case. It was a ton of individual personal injury cases that had been lumped together in complex lit. They won. And I will tell you, as of last year, there has not been cleanup of the hexavalent chromium in Hinckley, California. And so what ended up happening instead is PG&E has finally just paid people to move. They're like, it's not going to get fixed. We can keep trying. It's probably not going to happen. But it's been over 20 years since that litigation happened. And it was interesting. There was an article, and one of the local newspapers went back and interviewed the community members because Hinckley was experiencing a significant drop in population. It lost, when I first started representing Hinckley, it had about 800 people, and now it's closer to the 200 to 300 level. So that's like over 5 or 6 years. And so it had this huge drop. There was a reporter who did a bunch of interviews with local community members and then went to Erin Brockovich for her comment. And she said, oh, it never got fixed. And I thought that was interesting because, that's something that one would hope that folks would oversee. But one of the benefits of transactional law is that sometimes the implementation of the policy is not an area of focus or expertise for litigators. And so sometimes having a transactional attorney on your team helps implement the win. So we also worked with organizations that had successfully sued local governments over environmental justice issues, and then were in the implementation phase of the judgment and didn't have technical expertise to be able to review whether there's contracts or protocols or policies around local hire and things like that were legally sound for their client and whether they actually would achieve their goals. And so some of what we were doing was also kind of filling a gap and helping to train up attorneys in the field on areas where it would be helpful to have someone who's doing the oversight but can also figure out when things are going wrong. So I feel like I've talked a lot, but I know that there's a lot of time still left. I think it might be helpful to break very shortly for questions. And then if I don't get any, which is highly likely, I'm happy to continue to go on, but I'd like to take a break, I think, right now, just to see if there's any movement, I guess. Yeah, you could type the questions. Sorry, I can see the chat box. I apologize. I should have been more specific. So I'll give people like 2 minutes, I guess. I don't want to make everyone wait in exhausted quietude. Okay, awesome. So the question is, what kind of clauses would we cover in a contract and how would you teach it to your students? And I think it means clauses specifically related to environmental justice. So some of the clauses that are not common in contracts, but that are fine to include ensuring that there's an adequate kind of preamble and also helping folks understand. So I kind of divide it. So there's a question here about, do you begin with a structural analysis? So typically the way I structure the class is the first 2 or 3 weeks is pretty intense for them. And it's just helping them understand the setup of environmental justice and equality in the areas where they work. And so we start with that, and then we start with the skills work. When we're doing contract clauses, there is an element of our class that is just straight up walking them through a refresher on contracts law. And they've got handouts and guidance also on kind of what are the key things you're looking for when you're reviewing a contract. So Tina Stark has an excellent book on drafting contracts. I use her book in part to also flip it and figure out how you draft contracts. So we go through kind of what is a clause, what's a binding commitment, what are some of the magic words in contracts, and then we have them apply it to the context of a specific contract. And one of the things that I always remind them is that their job as lawyers is to try to identify what's missing. So oftentimes we forget to ask who's not in the room or what is not there that ought to be there. And so part of what they do through the kind of take-home exercise on contract review, which they also do real contract review for real clients later, but that doesn't always happen every semester, is for them to think through what's missing. So they come back to me and they'll often ask me questions about, do we have a translation policy? So that's an example of a clause. Is there language access written into the contract? Is there a consultative process in the contract, and what would that look like? Are there set commitments about affordability or not allowing certain things to happen? So, for example, particularly if there's a consolidation of water systems, so merging of water systems, we will often look for an affordability statement, because typically what will happen is that folks will merge a system and then they'll start charging a higher rate to low-income people who are brought into the system, which is technically illegal in California, unless you can justify why you did it and why it was economically necessary and why it's distinct from folks who are already on the system. So we'll look through things like that. The other thing we look through is if there's funding, we look at the cost sharing. So we take these kind of traditional contracts clauses, and then we also add clauses that are not traditional at all. And we walk through what those could look like, but in the context of a specific client. And I mostly make them review things. So I'll give them an example of a quote unquote bad contract, and that's kind of the review assignment. But then I'll also give them a model later on, usually at the end when we debrief the assignment in class. I'll give them a model of like, what would a good version of this contract look like, so that they can see kind of what a model could be. And that's really helpful, because at least I have only one student I've ever had who loved contracts. So part of it's helpful too, as just a refresher of the law. Okay, so I also have a question that says, the nature of the project sounds like they're time heavy. How do you navigate projects across semesters? That's true. They are time heavy. Transactional projects can sometimes be challenging because they often take years to complete. So I have a client who we took on in early 2017. They are just now getting their deliverable out the door. Transitioning it across semesters was not as hard as I thought it would be. So we do kind of the same things everyone else would do, which is transition memos. I have advanced students. If they come back, they often serve as kind of a senior associate, if we were talking about the law firm model, for the case. And so they have some institutional memory and help bring their colleagues up to speed. I also make my advanced students, this is not in the Community Economic Development Clinic at Irvine, but when I was at Davis, I used to make the advanced students also teach a course on a topic of their choosing. So I had a hydrologist once who taught people how wells work and how groundwater works, so that folks could just kind of understand the engineering and science mechanics of the work we were doing. But yeah, I mean, it is time heavy. I don't think it's a lot different than representing any other kind of client, though. I guess if you're doing like very specific and limited representation that's like very time sensitive, I understand how that could complete in a semester, but transactional law is just, it often takes more than a year. And so I haven't had any issues with transition or handoff, but a lot of it is building in kind of oversight and deliverables and goals. So one of the things that is in the transition memos that the students write is like, here were the deliverables we think needed to happen or that we accomplished. Here's what didn't happen. Here's our idea of like whether we believe there needs to be additional community support or engagement, or we spoke to these representatives, but we're concerned that there wasn't democratic representation from these other representatives. So they call out the issues. And the helpful thing about it is because they're doing it at the end of the semester when they've been through an entire semester of talking about each and every one of these concerns about democratic accountability and transparency and participation, they start to become really good at asking questions and calling out the questions, even if we don't always have the answers. Okay, how do I differentiate transactional work from other types of EJ, including commenting during rule development? So we do some, this is a great question. So we do some administrative advocacy, so comment letter writing. And we do sometimes do strategic research that is useful to advocates about how a rule or a policy might want to be shaped and what the important considerations are for the regulatory agency that might be developing a program. But transactional work is I guess the way I differentiated it is, or the way it kind of lines up in my head is I think there's policy advocacy, which can include administrative and regulatory advocacy. There's litigation and direct representation, which are distinct but can be related. And then transactional work is kind of, the way I describe it to my students is that it's the law of deals. It's the law of how people work together. And it's how they work together outside of governmental processes. So even though I do sessions on local government and on commenting and administrative process, and they often will have to write a comment letter as part, like in the course of their semester, just because I think it's important for anyone trained in environmental practice to write at least one comment letter. Transactional law is often things like, did we incorporate, so for example, we had a community that didn't hold title to their well, but kind of own their well. So we helped them incorporate a cooperative where they all own their water and they own their water system. We assisted communities with obtaining tax exemption. We consulted on a bill, which didn't go anywhere, but it was on kind of ensuring there was tax exemption for water co-ops. So there's real kind of nuts and bolts traditional quote unquote business law ideas in transactional law that are just significantly different from the practice of like rule development, litigation, investigation, and all the other kinds of things that we traditionally see students do when they do environmental justice work. And so I focused on contracts, but like I said, we do a ton of entity formation, we do compliance and support, we do capacity building through direct trainings, both with communities and with boards of directors of water co-ops. We help folks understand what their role is when they are, like kind of what the democratic management expectations are when you're in a co-op. We also help them connect with other organizations or communities that are like them so they can exchange best practices and build power. So one of the most effective things we've seen is if we're able to facilitate our clients meeting each other, it will often amplify their benefit, their sophistication, and their ability to make change around things like a rule process or something else. We can help facilitate that, but because we're really trying to help them build power and because we don't want to be leading our client, we want to be supportive of the client without essentially like kind of persuading the client into doing things that maybe are not actually closely related to their outcomes or objectives. The advanced students get a little bit more distance or more of a kind of like 60-mile or 100-mile view of the system as a whole. And part of why they have to do a movement building project is because I want them to be able to look across our clients and see what the systemic themes are that seem to be impeding our clients from being able to build power and achieve their goals. Okay, how much teaching time do I allow for teaching EJ through consent decree enforcement? Not a lot, although it's not a lot, but it's mostly because California law has changed on the issues that we are most focused on in water. It hasn't changed on other areas of environmental law. We do look at consent decrees and we talk about the role of a consent decree, particularly because consent decrees are a form of contract drafting. And they're contract drafting in the litigation context, the same way a plea bargain is contract drafting in the litigation context. We talk less about the consent decree as the vehicle and more about kind of here are common types of contracts that you might see that are relevant to our clients. We definitely co-counseled and worked with a community that had obtained a consent decree through litigation. This was hilarious. The defendant who had lost pretty soundly then went back and tried to get the court to basically vacate the consent decree, which was crazy. The basis for doing it was completely irrelevant. And the other thing we did was, honestly, they were trying to do a series of things that violated the consent decree, but through other local government processes. So we were watchdogging with a local community partner who's a powerhouse legal group. And so through co-counseling, we did a little bit of consent decree enforcement. So I don't allocate a lot of time to it in the seminar, but I do allocate time to consent decree enforcement when we have specific cases. Okay, I have a contract on, do I teach plain language contract drafting? Yes. And it says, is it considered a transactional EJ tool? I think it is. There's of course there's a spectrum of legal practice. And of course, transactional law is not isolated from other forms of legal practice. And they certainly overlap. But yeah, we do plain language a lot. We spend actually a lot of time on on things like, how would you rewrite this bylaw for it to make sense? And I know that sounds silly, but usually I start a lot of their early drafting with review instead, because at least for me, I found that I became a better writer when I became a better editor. And so, so we do a lot of plain language drafting. And we talk about how if you are reading about a contract that is in a court case, it was probably not very well drafted, to be honest. It's not a great model. Sometimes they're in there even though they're well drafted, but we talk about why it's dangerous to borrow models from litigation and kind of other places where you could find plain language opportunities. And then I give them examples of what a plain language clause could look like. And it really helps them then reframe how they think about it. So I know we're supposed to do the kind of the less directive, I guess, when we're doing clinical pedagogy, but unfortunately, or let me back it up. The Chronicle of Higher Education recently came out with a series of articles and studies showing that if you do pure lack of directiveness as the model, it's often overwhelming for students. And so my approach has been to try to give them foundational tools and models so that and help them figure out how to find those tools and models. And then to like do kind of a question-based or less directive method from there. Certainly I'm not at all directive with my advanced students, but there is a little bit more kind of framing, I guess, for my first time students. Just because the area of practice is also so rare. At the moment, I'm the only transactional EJ attorney in legal services in the country, or not in the country, sorry, in the state of California. I think there's 2 or 3 others, but it's not a common area of public interest practice. And so, just they need a lot more framing just to understand kind of how we got here. Okay. Okay, so I have a question. I'm not sure I fully understand it. It says, how much lead to cover what it is, class time to work through a hypothetical, other ideas in setting up the hypo, and adding the EJ analysis. So if that question person could refine that a little bit for me, I'm happy to answer it. I'm not sure I fully understand the question though. So I'll skip and come back. So I have another thing that says, our students have never heard of community lawyering or movement lawyering. They often have no framework. Do you have early readings to ground them to understand their role? Yes. And it says, the way you define it with an EJ seems pretty different from popular media versions of how lawyers are. I also got a comment that says contracts is fun, and I'm glad that other people find it fun too. But yeah, so most of them have not had community lawyering or movement lawyering. So the class actually doesn't start with readings about environment, if that makes sense. It starts with readings on community lawyering and environmental lawyering. So in EJ, we're lucky because we're lucky because there's not a large canon of writing in the law on EJ. But some of the best books on EJ are actually trade publications. And so those are much more accessible for students. So I'll often assign excerpts of From the Ground Up by Luke Cole. And then I also, as recommended but not required reading, I give them Scott Cummings' CED as Progressive Politics. I also will usually give them, let's see, there's a Luke Cole excerpt. I usually give them excerpts of Luke Cole's Macho Law Brains, which I actually think is helpful even for non-environmental people. It talks about 3 models of public interest lawyering. And so that helps them break things down. And so we spend the second class essentially critiquing that reading and seeing if we agree with the classification. So he talks about essentially the grass tops model of impact lit, and then he talks about the participatory model of lawyering, and then the power model. And I found that in terms of discussing power as an objective, it's one of the shorter and more accessible readings that I've been able to give them. I also have like a whole bibliography of other pieces that are not specific to environmental justice. I don't assign a lot of them just because the students, there's just no way they could read it all. But I'm also lucky because when I was at Davis taught a community lawyering class. And so some of my students were cross-enrolled, and I heavily encouraged them to cross-enroll. And so they were able to bring what they learned in that class into clinic. Okay, do you find that students resist the model or lawyer as defined in the clinic? Yeah, some of them do. I often try to preempt this by being very specific and overt about what the clinic does when I do our informational structure, informational sessions for new students. It's different here at UC Irvine because there's a mandatory clinical requirement. And so I'm just now wrapping my first semester as a visitor. And so it's been really interesting to see what that resistance looks like. I've been lucky because oftentimes if students apply, when I was at Davis, if students applied to my clinic, I was very clear about the model we were going to use. And so most of them were not resistant to the model because they had opted in, but some of them found out when they actually practiced that this was not what they wanted to do, and then they got resistant. Or they felt like they were out of their depth and lacked tools to figure out how to do it. So part of how we went through that is that we would run some of the early sessions we would talk through the articles almost as if we were doing a rounds session. And I found that that was a little bit more helpful for them because then by asking questions, they could surface their own answers in a way that wasn't as effective if I told them, like, here's a model, here's what we're doing, here's why I think it's important. Particularly because movement lawyering and community lawyering has such rich literature and is really pretty nuanced. And I'm only presenting one very specific kind of idea of it, which is not necessarily shared or canonical. And so a lot of it was helping to like ask them questions to try to get through an understanding of why might the role of a lawyer be different. So having that article about the power model of lawyering was really helpful because then when they're resistant, we can ask, okay, well, how does that approach build power? And for the most part, when I ask them that question, it helps them critically re-examine whether or not the model that they think they want of a lawyer, which is often kind of the model we see on TV, is useful or accurate for the client. So, we talk about how litigation is often a disempowering process for clients, that, the lawyer is kind of the protagonist and controls the strategy, that courts are not places that are welcoming to a lot of the communities that we serve. And so after we go through that kind of a discussion, then when they start resisting this idea of having to, because I do have students who don't enjoy having to talk to community members, I will say that. And I think they don't realize it at the time, but it often comes off as kind of condescending, like, why don't these people know better? And so I've found that questioning and guiding them through questions has been really helpful. And I can try to put together a list of kind of ideas and questions that I have, or that I have like, it's built into my teaching plan or my session plan for each seminar. So I'm happy to share some of those resources with folks. Okay. Is there a structural analysis of civil rights within a transactional context? I think yes. So what I will often start with this, so I kind of teach things it's hard to teach all these concepts at one time. So usually the lead teaching is just kind of orienting them on how California environmental justice policy works at a very high level. And then they do these readings on community lawyering, movement lawyering, and power building. And then the second set of readings that they do are related to the history of economic resistance and economic empowerment from communities of color. So I have them read about freedom colonies. One of our clients is a freedom colony. I have them read about economic resistance during the civil rights movement and Jim Crow. I have them read the Black Panthers, a section on the Black Panthers on the 12-point program and, free breakfast and where that came from. And then they also read some of Dr. Martin Luther King Jr.'s late speeches when he was engaged in the Poor People's Movement. And so I really want them to understand that people have agency in economic processes, and that communities of color in particular Black communities have existed and have exercised economic solidarity and resistance since the time of slavery, essentially, and predating slavery. But within the United States, there is an indigenous not in the sense of Native communities, but indigenous as in existing and already there, and a value system has been there from communities committed to excellence and empowerment and solidarity within their community. So it's a pretty overt kind of race analysis. And then when we talk about it in the context of transactional work, I assign some of the critical race readings that exist to talk through kind of contracts. Gosh, I think Charles Miller, I might be blanking, but I do assign some excerpts from there. We talk about like, are bylaws neutral? Like, what about we read like about the nonprofit industrial complex, and then we like talk about, because we work with nonprofits, so we talk about, even though there are these critiques, what do we think of these critiques? What do we think of the history of XYZ? So I try to help them understand that transactional process is not neutral, or transactional practice is not neutral, in the same way that nothing else is neutral. Everything is structured through social processes, and there's the kind of slogan, one of the catchphrases in environmental justice is that there's two kinds of power. There's the power of money and the power of the people. And so we talk about how the power of the people can be used to create a more just distribution of money and resources through transactional law. Okay, sorry. So the person, thank you to the question asker who restated their question for me. So the question is, how much lead time does it take to cover what a dissent decree is? So this, I think, is asking a little bit about the amount of prep time it required, as well as the class time and other time it requires to do the EJ analysis. So for me, it didn't take that long. It took no longer than if I was going to be assigning a contracts hypo anyway, I guess. So it took me about, I would say, 10 hours to put together the original hypothetical and the practice. And then I was going to teach contracts drafting anyway, so teaching it in the context of a specific assignment was not super hard. I spent about 3 or 4 class sessions. So our class sessions are a little bit under 2 hours. So 3 or 4 class sessions on contracts, consent decrees, understanding how things are set up. And then we would spend at least 1 full class debriefing the hypothetical assignment that I talked about. In semesters where we have a real assignment, I don't always have folks do the hypo, or I won't have that team do the hypo. I'll have that team come back, and then we'll do rounds after we debrief. We'll spend the next class on rounds talking about what they saw in the contract, what they missed, how the assignment affected how they read the contract, and things like that. But I assign it out of class, so I don't have them do it in class because I don't think that's realistic. And it takes most of them, if they're doing it well, it takes them about 8 hours max, I would say. And that includes taking time to interview the client. So some of them will not interview the client. It's not required. I basically say, if you want to interview the client, like, let me know. And I give them, there's like, I can make the assignment available for sure, but there's a prompt, and it took me about 2 to 3 hours to put together just the actual assignment and the prompts and the directions. And the scripts. But other than that, it didn't take a significant amount of time compared to my typical class prep, I would say. But it was interesting to see kind of how students allocated their time. And then it was interesting too, because when they debriefed together, they could ask each other about what someone had done and not done. So like one person so there were certain clauses in there that were unacceptable to the client, but if you never talked to the client, you wouldn't know that. And so it was interesting, and it was helpful to have the class debrief so that folks could be like, oh, that was the benefit of talking to the client. But yeah, so it was pretty fun. I'm happy to share it with folks because it was inherently it was based on contracts that I've worked on already that are in the environmental justice context. So infusing EJ was not as hard. Infusing EJ was not as hard. But I think also it's because we've done a little bit of framing leading up to it. All right. So I'm not seeing any more questions, but I think we're also almost out of time. So I'm happy to share all my resources on this. And I would encourage folks to think about how they teach transactional law or how they teach environmental justice, because I think there's a lot of untapped potential there. And one of the benefits of transactional law is that there's elements of it that feel like, that could feel as removed as a lawyer being in the courtroom litigating a case, or removed from the client, I mean. But there's also a way to do contract drafting in a collaborative way with the client. And so some of it is also trying to figure out how to build capacity for the client. Some of what we do is also helping the client read their contract and helping them understand what's going on. And so I think there's a lot of opportunities within that for transactional law to be more meaningful and to carry greater weight and greater impact if we think about it as just another tool to help restructure inequality and power dynamics. Or not restructure inequality, but like redress inequality by deconstructing it and coming up with alternative structures. I will say a lot of what we do is also, like, you can't really write bylaws, for example, unless you sit down with the client and you talk about their conflict management process. So in the process of doing this transactional work product, you can do a lot of client counseling and client-centered counseling that helps strengthen capacity and also helps produce really useful and helps produce really useful outcomes for the clients so that they think through and they learn, like, kind of like, oh, we don't have bylaws just because we need them to apply for tax exemption. We have bylaws because they help us set out a conflict management program. Or we created this entity because we've decided that it is more important to us to acknowledge the labor and input of each community member than it is to prioritize individual wealth. And so when I talk to students about these models, we talk explicitly about the pros and cons of different entity types in the context of power building and economic inequality and racial inequality. And so, yeah, I just want to encourage folks. The CED people talk about this all the time, I think, but I do think there's a lot of opportunity for collaboration, and there are some clinics who have done some really cool collaborations between their community economic development clinics and their environmental law clinics to address these kinds of more transactional and structural inequalities. The other huge benefit is just if we are generating and supporting enterprise and economic development that is an alternative to our current system of heavily polluting, heavily exploitative, and dysfunctional economic production, then we're building that other world that's possible. And that's really the end aim of environmental justice, is to build a healthier world. And so we have to, I feel like oftentimes when we're in public interest or when we're working with vulnerable communities, we're often on our heels. We're helping to defend or protect our clients from bad things that are happening. And our clients rarely get the opportunity to affirmatively shift from being on the defense to kind of being proactive or affirmative in claiming justice and claiming space to create a more just world. And so I think the promise and the benefit of transactional law is that it helps us kind of do both. And so I don't know, I just think it's a really fun partnership. And I think there's like a lot of opportunities across a significant number of areas, I guess, and a significant number of transactional tools that can help folks really think through obtaining these social justice ends and these environmental justice ends. Yes, I'm totally willing to share my slides and exercises. Sorry, I just got a question. I am super happy to do that. And I'm happy to share some of my lesson plans too, if that's useful to folks. And then I can't remember if we go all the way out to 10:15. Layla and Allison, can you remind me? Okay. We can wrap up now is what I'm hearing. Excellent. Well, if you have any other questions, please don't hesitate to talk to me. I'm super happy to kind of go through how I thought through some of this. I did rely very heavily also when I structured my class on some of the more traditional, or not traditional, but there's wonderful books and resources out there by clinicians for clinicians. And so it's not always as daunting as it seems, I think, to teach transactional law or to help folks get into transactional law. And so if there's anything I can do to help facilitate that or to help connect people to resources, I'm happy to do it. So with that, I'm going to throw it back to Allison and to thank you all so much for your really awesome questions and for participating in this. This was really exciting for me, so thank you.
I just want to thank you all again for joining us, and thanks so much to Camille for this amazing presentation. The recording will be available through on the CLIA website that has a link to all of our webinars, past webinars from the Teaching Justice series. And just want to highlight again that our next Teaching Justice webinar session will be held on January 23rd, 2020. We will have Aaron and Lisa from the Movement for Family Power and Bobby from Starting Over Inc. Joining us to talk about family separation and keeping families together. So happy holidays to everyone, and thanks again for joining us. Take care.